So extending a very warm welcome to Dr. Alvaro Fernandez-Mora. Alvaro is a lecturer at King's College London, and he moved to King's College only in January, having worked for about a couple of years in York Law School. And Alvaro and I met when we were doing our doctorate together at Oxford, and we had a common supervisor. That's how I know Alvaro very well. And his area is trademark law, and like we were just discussing right now that most people who teach trademark law have not had trademark law as their research area. We just happen to also teach trademark law. That's particularly the case with me. But with Alvaro, he's really deep dived into the area, and especially trademarks and free speech is drawn from his doctorate. So very privileged, very happy to have you here, Alvaro. Warm welcome to you, and over to you.
Perfect. Thank you very much, Purna, for the warm welcome. And well, thank you very much for the invite. I'm delighted to be here. And thank you very much for everyone who's joining us today, whether in person or online. I mean, as you can see from the title of the presentation, so my ongoing research, and this has been research that has been going on for a while now, lies at the intersection between trademarks and speech. So the main focus of my presentation today, as you will see, is try to sort of challenge sort of the conventional wisdom that exists in the sort of in the scholarship, especially when it comes to the interaction between trademarks and speech. And so the idea is that, well, my contention, my main argument is that our understanding of that interaction between trademarks and freedom of expression is rather limited. Is impoverished by the fact that we tend to be focusing only on one instance in which trademarks and freedom of expression are interacting, which is mostly in the infringement context. And I think it's important that we try to adopt a taxonomical approach, or sort of a more holistic approach to understanding this interaction between trademarks and speech. My argument is that this will allow us to have a better, more sophisticated understanding of that interaction between trademarks and speech, which can ultimately allow us, and in particular decision makers, to reach better balanced, fairer results in interaction cases, but also hopefully it opens the door to the rethinking and reconceptualizing of this interaction, in particular in terms of the conceptual frameworks that we may want to employ moving forward when it comes to trying to understand this interaction. So this is sort of the core argument of the research that I've done so far. But again, this is just very much the first stage in the research. In order to argue this, I have structured my presentation into three parts. And so first, I'm going to be introducing, hopefully briefly, how trademarks are conveying expressive meaning. So what do we mean when we say that trademarks are operating as expressive artifacts? And then we'll be looking at how trademarks and speech interact. So how come we have litigation and instances in which the fundamental right to freedom of expression is triggered in trademark litigation and in the trademark context. One thing that I should mention at the outset, and hopefully this was clear from the title, but I think it's worth mentioning, is that my approach to the topic is very much comparative. So I'm looking mostly at US and Europe. The main reason for looking at the US is most of the scholarship and most of the case law, especially until recently, was coming out of the US. And so it made a lot of sense to try to sort of look at what was going on in the United States. But also one thing that I think is interesting, and I will say this from the outset, but hopefully it will become clear as I explore the different ways in which trademarks and speech interact. One thing that I think is quite interesting and hopefully also a bit striking is that there are clear parallelisms between what is going on in the US and what is going on in Europe. So sometimes we tend to think that what is going on in the US is different because of how the First Amendment is structured and the role it plays in the US, which is understood to be, sort of different to what is going on here in the fundamental right to freedom of expression under Article 10 to the European Convention on Human Rights. But hopefully what we will see coming out from this comparative studies that sort of both right holders, sort of defendants in infringement cases, and courts are doing similar things in terms of the analytical frameworks that are being employed. And so I think we can also extract valuable lessons from that comparative analysis. Then briefly look at the implications of my proposed approach and sort of future work that can hopefully come from here, and then open it up for questions in the Q&A. In terms of trademarks as expressive artifacts, hopefully we're all familiar with the fact that, well, trademarks, their subject matter is signs, and so therefore signs convey meaning. Sort of at the end of the day, signs are units of language. So the words that I'm using now are signs. They allow us to communicate, as the same principle applies in the context of trademarks. insofar as they're signs. And so by conveying information and through their use, they enable communication. The idea is that the meaning that signs convey is dependent on social consensus. And so the meaning of signs does evolve. This is true of language, but it's also true of trademarks. And trademarks, we have seen them going on quite an interesting, fascinating journey over the last few decades, where the meaning and the information conveyed by trademarks has changed quite drastically in the last few decades. And so now, hopefully, we're all aware of the range of functions that trademark perform in the marketplace, which have been recognized by sort of European courts, the Court of Justice. So it's true that we tend to refer to trademarks, or sort of the core function is origin signaling. They are signaling commercial source or origin, but we're also aware of other functions that trademarks are performing. And this is thanks to trademarks being signs and the meaning in signs evolving. And so they also convey information as to quality, sort of advertising function. So, trying to inform and persuade consumers, the investment function, the idea of the using the mark to acquire or to preserve a reputation, and then also the communication function. So the idea that we can also use marks to express preferences, lifestyle choices, or values. And a lot of what I'm going to be talking about today and the instances in which freedom of expression tends to sort of come into play in the trademark context is when we're talking about sort of that communication function or that expressive function. It's true that from a European perspective, the Court of Justice hasn't given us a lot of guidance in terms of that communication function. I will try to sort of give it some content, but the idea, and there is, sort of quite widespread consensus nowadays, certainly in the scholarship, but also we see this in this case law, especially sort of US case law, the idea that trademarks are performing an expressive function, and it's a function that is allowing different individuals, not only the trademark owners, but also consumers, and also artists, parodists, commentators, to rely on these complex meanings to try to sort of pursue their own expressive agendas, their own identity agendas. And so, I mean, this is just an example, but hopefully an example that, sort of we're all familiar with. So the Apple logo sort of giving us information about commercial origin, information about Apple Inc., sort of based in California. It's also giving us information about quality and reputation. I know when it comes to Apple, this is debatable and different people in the room will have different views, but, hopefully quite a few people would agree that, well, it's high quality, it's reliable quality, it's good design, is innovative, but also sort of the Apple brand and sort of other well-known, sort of reputed strong brands nowadays also giving, sort of other types of information, conveying other types of meanings that are more linked to values or lifestyle choices or preferences. As regards Apple, so the literature talks about it being sophisticated, being hip, creative, design conscious, being stylish, and the idea that now we can harness this logo. Again, it's only one example, but we can harness this logo when we consume Apple branded products or when we use them in order to express who we are and some of our lifestyle choices. This is also true if we think about sort of clothing, apparel kind of brands. And so we are trying to sort of convey who we are, and we're using these brands for expressive purposes. I mean, if we think about sort of the literature, for instance, sort of Rochelle Dreyfus sort of being sort of one of the first people to say, trademarks are working their way into the English language. There is something about certain trademarks that now is going beyond signaling origin, commercial source. And now, they are performing other types of functions that are sort of expressive, and people can use them to express themselves. Also, of course, as you can see here, sort of Judge Kaczynski very, very clearly said that, trademarks can be imbued with expressive value, and then the trademark becoming a word in our language, assuming a role outside the bounds of trademark law. And more recently, the US Supreme Court, this is from the I think it's the Tam case, sort of trademarks are speech. So the US Supreme Court very, very clearly they're saying, even though trademarks are limited to what kinds of messages they can convey, because they tend to be, sort of short words or logos, but they can convey very powerful messages. Therefore, they're speech. And the moment that we agree that trademarks are speech, that's when the fundamental right freedom of expression can be triggered in trademark litigation. And so now we're going to be moving on. Now that we understand a little bit better how trademarks convey expressive meaning and how different individuals can use them to express themselves, the idea is to try to understand a bit better how trademarks and speech do interact. And so the first thing that I want, so the first instance or scenario in which trademarks and speech interact, and this is probably the one that we're all more familiar with, is in infringement litigation. So in the infringement context, this interaction, which I argue has held sort of the narrative captive insofar as we have spent a lot of time and energy focusing on this specific instance of interaction between trademarks and speech. The idea is a third party makes an authorized use of a well-known trademark to try to convey their own expressive meaning or to pursue their own expressive agenda, usually by modifying or recoding the well-known trademark and using it for commentary, parody, critical purposes, right? The idea here is then, well, the trademark holder is not happy with this unauthorized use of their trademark, so they sue for infringement, usually on the basis of dilution, but not only. We also find a lot of instances where infringement is on the basis of likelihood of confusion, but in most cases, because these are very well-known trademarks, it's on the basis of both grounds. And so then what we see is defendant trying to invoke or mobilizing freedom of expression, the protection granted to the fundamental right to freedom of expression, as a way to try to shield its unauthorized use in that infringement context. And so what I'm trying to sort of argue here is that because we have focused a lot on the interaction between trademarks and speech in the infringement context, because of course scholars became very concerned, especially the first few cases, courts were quite critical of this reliance on freedom of expression, so they weren't very eager to shield these unauthorized uses against infringement. A lot of scholars, so that triggered a debate, and a lot of scholars got very worried and started saying, well, maybe we can mobilize speech to try to sort of insulate these kinds of uses, because these are uses that we want to incentivize and allow out there in society, and we don't want trademark rights, and in particular the over-expansive protection of trademark rights under anti-dilution protection to be used as a way to chill these kinds of expressions. Okay. And so what this has led is what I'm saying is because we have focused so much on that specific instance of interaction between trademarks and speech, the conventional wisdom now when we tend to talk about trademarks and speech is to think automatically about, parodic uses, commentary uses, critical uses, and speech acting as a limit to trademark rights and trademark rights chilling expression. Okay. And so what I do try to say is that we need to move away. So we need to, take a step back, realize that trademarks and speech interact in other instances, and this can have implications for how we conceptualize that interaction. As you can see here, these are just sort of 5 examples, but I should mention that most of the ideas or all of the ideas that I'm covering today have been published in an article with the Berkeley Journal of International Law. And I do give a lot of examples, especially in the footnotes, of authors saying, we should be worried about this, right? Like these are expressive uses of trademarks that we want to allow. If courts continue down this line of prohibiting them by agreeing that there's infringement here, we're going to find ourselves in a very difficult and uncomfortable situation. So we do need to rely on freedom of expression to try to sort of stop or prevent this from happening and growing. Okay. Again, you can see from sort of those examples, most are coming from the US, but I did try to sort of also look at European examples because this is a debate that is happening on both sides of the Atlantic. I'm going to be showing you some examples as a way to try to sort of historically understand what was going on and the context in which this debate was happening. But just bear in mind that these are just some examples, okay? Especially for the US, there's way more cases. And if you read through the article, which I do encourage you to do, you'll see that there's many, many other examples. Okay, and one of the reasons why this area of law in the US has been so sort of complex is that it's been very litigious and different courts have been doing many different things. And so there's a bit of a cacophony between what is going on within different, sort of between different circuits. And so this is ultimately also leading to some inconsistency. The US Supreme Court has recently sort of decided a case in this issue. So the idea is that maybe there will be a little bit more clarity moving forward, but people aren't happy with what the Supreme Court has said. So the first few cases, and you can see here, we're talking about the 1980s. The first few cases that I mentioned earlier, the courts were quite skeptical of invoking speech protection, sort of in the case of the EU under the First Amendment to the US Constitution, to try to shield defendants' unauthorized use. And you can see here sort of that sort of early suspicion, so the court saying trademarks are property rights. They do not need to yield to the exercise of First Amendment rights under circumstances where adequate alternative avenues of communication exist. And the court says there are numerous ways in which defendant may express his aversion to nuclear war without infringing upon a trademark in the process. So we can see there is a bit of a suspicion, and the court saying the First Amendment provides no defense in these kinds of instances. Okay, and so another example is the Hard Rain Hard Rock Cafe case. Here, the court was very concerned because, okay, this seems to be a parody. We get that, but your parody is so very similar to the registered trademark, the well-known trademark in this case, that, I mean, it doesn't really seem to be operating as a very successful parody. This is something that should be prevented, right? And so these are cases in which we see that use was not permitted. And so the courts, sort of finding for plaintiffs and for infringement in these cases, which again, sort of earlier cases, 1980s, 1990s. I do want to give examples also of uses not permitted in Europe. One thing I should mention is that courts in different European states have done quite different things. It is difficult to sort of, very briefly summarize what is going on in Europe, but just to let you know, there are certain jurisdictions that are a bit more skeptical of mobilizing freedom of expression to try to shield these kinds of unauthorized uses, especially sort of English sort of high court. Sometimes, sort of the precedents we have not very sort of often finding, well, it doesn't seem as though these are really expressive uses that should merit protection under the fundamental right to freedom of expression. Also, France, a bit skeptical. In France, it has to be very clear non-commercial use of a trademark in order for the courts to actually be happy to apply freedom of expression. This is just an example. I think it's an example that I chose it because it's quite visual. So the kind of impact that this can have, sort of this unauthorized use can have on the trademark, and in particular, sort of in terms of linking sort of this trademark in relation to tuna with sort of oil spills. Well, clearly we can understand how that can have a negative impact on the image of the trademark and how the right holder might be unhappy with this, and the French court not being persuaded that freedom of expression had much to do here. What I do want to say, and this is to be hopeful, although things have changed a little bit quite recently, but after these sort of earlier cases, especially in the US, and especially because the scholarly debate was very adamant that we should protect these kinds of uses, freedom of expression should be doing a lot of work here, we start seeing that in most cases, these unauthorized uses are allowed. Okay, so, sort of rest assured, or, sort of give us some peace of mind. It seemed for quite a few decades, especially sort of the late 1990s, but then, sort of until quite recently, most US courts were actually sort of very rarely finding for infringement. Again, in Europe, it's a bit different. It depends usually on the jurisdiction. As I mentioned, sort of England and Wales, more skeptical, France, more skeptical, Germany and the Netherlands, sort of, more easily finding in favor of defendants and willing to mobilize freedom of expression to try to insulate these kinds of uses. This is a very well-known case from the Netherlands. It is based on design rights. So that's important to bear in mind, but just so that it is very often studied in the context of sort of artistic or commentary uses of IP rights. And the sort of Dutch court here very clearly saying, this is artistic expression. It should very much be allowed, even if Louis Vuitton here, we can understand why it might not be happy to have its, again, debatable, but here sort of that's what Louis Vuitton was saying. Very relevant case. Again, these are just examples. There's many more examples, but the Barbie girl case, so a very well-known case in the US, sort of Aqua making use of sort of Barbie girl in the title of the song, but also the lyrics of the song. And here, sort of Judge Kaczynski quite easily satisfied that this is the kind of expressive use that we want to be allowing, right? And so therefore, not finding for infringement, whether under likelihood of confusion or dilution. Another example, and this is a very well-known case, so the Louis Vuitton case. So here, plush toys for pets, sort of very clearly, sort of parodying sort of the Louis Vuitton handbags and sort of the trademarks and the designs. But again, here, sort of the infringing sign or allegedly infringing sign is being used very clearly in the course of trade as a trademark, right? Because sort of pet toys were being sold under the Louis Vuitton trademark. And so Louis Vuitton here sued for infringement, quite unhappy, both on likelihood of confusion and dilution. And the court here didn't find that there was infringement. And one thing that I think is quite interesting is the court here said the fact that the facts imposed on Louis Vuitton an increased burden to demonstrate that the distinctiveness of its famous mark is likely to be impaired by a successful parody. So here we're in the context of dilution. Because the famous mark is particularly strong and distinctive, it becomes more likely that a parody will not impair the distinctiveness of the mark. So here's quite interesting. It seems, a bit of an counterintuitive approach where the better known that you are as a trademark, actually the less protection you will be getting, because the more difficult it will be to prove that this is having any sort of negative impact on your reputation. So after this case in particular, you can see this is from 2007, especially scholars, felt more at ease that freedom of expression was doing, sort of the good work, and it was doing what it needed to do. The problem now becomes in 2023, so very, very recently, the US Supreme Court was called to sort of decide on a case that's sort of also similar in the context that it also deals with plush toys for pets. In this case, the Bat Spaniels case, very, very recent case. And here the court was actually quite skeptical of how much work freedom of expression, and in particular, the First Amendment, should be doing in these kinds of cases. And here the court was saying the problem is when a mark is used as a source identifier, right? So once you're using the trademark, the sign as a trademark to convey information as to commercial source or origin, things are going to become more problematic, and it's going to be difficult to be able to shield that unauthorized use on the basis of freedom of expression. The court does acknowledge, though, that because this is a parody and it is a successful parody, it can make a difference in the standard trademark analysis. And when we're looking at likelihood of confusion, it is a factor to bear in mind by the court. But it doesn't mean that sort of First Amendment protection will be triggered automatically, like a lot of courts in the US were doing until then. And so therefore, it remanded for the lower court to sort of, under this new way of interpreting it, what would happen. But of course, here the worry is that it will open the door for sort of more easily finding in favor of plaintiffs, and so therefore more easily finding that there's infringement. As regards to dilution, the court was also very clear, because this is an authorized use of a sign as a trademark in the sense that it's, sort of being used to give information as to commercial source or origin. Here, the First Amendment, doesn't really do much also in the context of dilution. And so therefore very much opens the door to findings of infringement moving forward. Again, it's still early days, but this is quite an interesting talk to do now. I mean, sort of this is work that was published a couple of years ago, but this case is very recent. And so it might, it sort of makes it even more relevant to have this conversation, because I think having this conversation will allow us to better understand this interaction and can hopefully give us a bit more clarity in what to do in these kinds of cases. So that's as far as sort of infringement litigation is concerned. And here, again, sort of going back to my main argument, is most of the conversation has been dominated in trademark scholarship by the interaction between trademarks and speech in the infringement context. And I'm not trying to say that this is not, sort of being very relevant work. I think it is worthwhile work. And I sort of also try to contribute to this debate, but I'm saying we are focusing so much on that interaction only to the exclusion of other interactions that we might be missing certain pieces that can help us better conceptualize the interaction overall. And so here what I'm saying is, trademarks and speech do interact in instances other than infringement litigation. We know this because there are scholars who are, sort of have been working in some of these areas. There's comparative way less scholarship in the other areas, but also no one has really looked at what happens if we looked at all these interactions together. Okay, and that's what I am trying to do here. Because again, my argument is our understanding so far is incomplete, and we cannot really engage in sophisticated analysis or sophisticated enough if we don't realize that, the repercussions or the way that we interpret the interaction in one instance might have implications for how we interpret it in another instance, and it might inform what should be happening, and hopefully it will give us more clarity. What I suggest to do is to adopt a taxonomical approach here. So, sort of a taxonomy of different interaction cases to try to conceptualize that this interaction, not so much as necessarily speech always limits trademark rights or trademark rights always chill expression, which is what happens if you only look at infringement, but rather their interaction operates as a two-way street where, sort of freedom of expression can both validate in certain instances trademark rights, and in other instances, it might actually limit it. Okay, we will see at the end why I think that this reconceptualization is relevant and how it opens the door to what I think could be better. Sort of a more refined understanding of the interaction and also better adjudication. This taxonomical approach then requires to look at other instances where speech and trademarks interact. And so these leads me to the ways in which speech has been mobilized in the registration context when trademark offices have refused registration of certain signs, in particular sort of signs that are deemed to be immoral or scandalous or go against public policy. So that's one instance. And the other instance is when trademark owners have mobilized speech as a way to try to challenge the validity of measures of public law that restrict the way, sort of the ways in which right holders can use trademarks. And I'm referring in particular to advertising bans, health warnings, and plain packaging of tobacco products, and in particular sort of restrictions on trademark use in the context of unhealthy goods. Again, these are just examples, but I have to say in relation to registration and restrictions on trademark use, these are the core examples. We don't have as much case law, but there is, sufficient case law, but these are the most relevant cases. So the Mattel v. Tam case in relation to the slants application for registration, which the USPTO considered was disparaging. This was challenged successfully. And so here what is relevant is the US Supreme Court considered really the government shouldn't be telling applicants what kinds of signs they should be able to register. That means that, so the government would ultimately be telling certain applicants, these are good signs and these are the kinds of signs that we agree with and these are the kinds of signs that we don't. And so what it did, and this is very relevant, it struck down from the Lanham Act those absolute grounds for refusal. So in the case of this Lance case, it was the disparaging clause that was sort of struck down from the Lanham Act. And then, and that's from 2017. And then in 2019, in the Iancu v. Brunetti case, where the applied for sign, which had been originally refused registration, is the FUCT or fucked trademark. And here it was on the basis of whether it was immoral or scandalous. And I guess the US Supreme Court in deciding this case considered this has to be struck down because, again, the government shouldn't be telling applicants whether there's, sort of good messages or good signs and bad signs. Very, very relevant. Basically, what this means is that this, sort of opens the floodgates to registering any sort of sign, whatever sign, regardless of how hateful the content might be. I did write another sort of article on this topic, and you would be surprised at the kinds of signs that some people want to register. But basically nowadays, sort of free for all after these two decisions. Again, on the basis of freedom of expression. So here, freedom of expression is doing something very different to what we saw in infringement. In infringement, it was limiting trademark rights. Here, it's sort of validating those trademark rights or the rights of the applicants in order to facilitate getting a trademark. We actually see a very clear parallelism in Europe. And this actually, I think sort of the Constantine film production or Fact You Get a case, very, very relevant case in Europe. In Europe, there was a big debate as to whether freedom of expression ought to be doing anything in the context of registration. And a lot of scholars used to say, well, it doesn't really have an impact on freedom of expression if you sort of are refused the registration of a sign, because you can still use it, right? It's just you cannot use it in exclusive terms, but if you don't get access to the register, you can still use it, so you can still express yourself, right? Here, what is relevant is the Court of Justice actually said freedom of expression is implicated in refusals of registration, and unsuccessful applicants can rely on freedom of expression to challenge the validity of sort of refusals of registration by trademark offices. It also said that because freedom of expression can be triggered, what needs to happen now is that the office cannot simply refuse registration of a sign that is immoral or contrary to public policy on the basis that in the abstract, the office considers this to be an immoral sign, but rather it needs to provide evidence. So the facto, because trademark offices are not in a very strong position to provide the kind of evidence that, a sort of substantial percentage of the people are going to be offended by these kinds of signs, it means that a lot of signs will now also have access to the register. And, sort of in Europe, and that's where I've done most of my work in this regard, in Europe, sort of trademark offices, sort of both the EU IPO, but also domestic trademark offices were very, they were doing a lot of work in terms of preventing these signs from being registered. But now again, sort of we see a change in that regard. And again, we see sort of that parallelism that was happening in infringement litigation where speech is mobilized in both the US and Europe to try to limit trademark rights. We see in the registration context how in both the US and Europe, especially sort of after this case, that, speech is being mobilized for the opposite effect, which is to, sort of validate trademark claims. And then the third instance, as I was saying, is sort of relying on freedom of expression as a way to challenge the validity of measures of public law that restrict trademark use. And so the way in which trademark use has been restricted, and this, sort of dates back to the 1960s, 1970s, especially in the form of advertising bans. But advertising bans are a bit tricky because most of them don't really impinge directly on trademark use. It tends to be, sort of more indirectly. But there is an instance of advertising ban that is known as brand stretching. So the use of trademarks that are often associated with tobacco products and other goods, or the use of marks that are often associated with other goods on tobacco products that, people agree that it has sort of a clear direct impact on trademark use, and being challenged on freedom of expression. We'll see both in the US and in Europe. I mean, in other jurisdictions, see also Canada, but we are focusing here in the US and Europe. Health warnings, also a lot of litigation, especially in the US, but not only, especially as they've become bigger and they've become combined. So both text and images, more challenges being raised by owners of trademarks, that relate to unhealthy goods, especially tobacco. But bear in mind that not only, so there's an expansion into other industries, especially alcohol, sugary foods, fatty foods, etc. And so we do find challenges. I should have mentioned a lot of these challenges tend to be based on the fundamental right to property, but in some instances also based on freedom of expression. And those are the ones that we're going to be looking at here. And then finally, much more recently, hopefully we're all familiar with it, plain packaging, because we find it in this country, which prohibits, sort of the use of most types of marks, so figurative marks, trademarks, protecting get up and trade dress, also shape marks. Those are completely prohibited. And then sort of you can only use word marks. And again, you are required to use them in a specific way. So it imposes very clear, very strict restrictions on how trademarks can be used. And so right holders, so that's an example. In case you're not very familiar with plain packaging, but, so that's how plain packaging looks like. And so these challenges, again, freedom of expression is being used or relied upon to try to sort of validate trademark rights of saying, there's so much that you can actually prohibit me from doing because I do have the right to express myself. And so the implications there being to what extent can right holders, successfully rely on freedom of expression as a way to challenge the validity of these kinds of measures. What is interesting, again, there's more cases in Europe and there's more cases in the US that I'm going to discuss today, but I just want to give two examples for flavor. This is a debate, first of all, that dates back, to the 1990s. So we find precedents in this regard in the 1990s, including in Europe, which I think is probably where I want to make a bit more emphasis because most people tend to find it surprising that we find these kinds of precedents in Europe. Here, unfortunately, the Court of Justice didn't end up dealing with this ground of invalidity for the Tobacco Products Advertising Directive of the late 1990s, because the entire directive was ultimately deemed to not be valid on the basis of relying on an invalid sort of provision of the EU treaties. But it's true that the Advocate General did deal with it. So Advocate General Fanelli, in this case, they deal with it in a lot of detail. And here, one of the ways in which Advocate General Fanelli considered that sort of freedom of expression was triggered was because of brand stretching, which is the example that I gave you earlier, where you're, so in this case, you're saying the Marlboro brand, for instance, which is linked to tobacco products commonly in the context of other goods. And so here, the Advocate General was very clear. It says, insofar as the application of such a brand or mark to a product also constitutes an exercise of freedom of commercial expression, I conclude that brand stretching has not been shown to be a justified restriction on that freedom and should be annulled. Again, the Court of Justice didn't get a chance to, sort of look at this, but, the Advocate General here very forcefully saying the moment that freedom of expression is triggered, and it is triggered in this case because the brand owner is not allowed to use the mark in the way that it wants to express itself, then we need to make sure that that restriction on freedom of expression is justified, right? And we need to follow the guidance of the Court of the European Court of Human Rights when it comes to restrictions on freedom of expression. And here, sort of the community legislature had not provided, sort of any evidence in relation to how brand stretching would lead to a reduction in consumption of tobacco products or a reduction in smoking. In the US, we do find more precedents, and actually, if you've been to the US, so in the last few years, when so many of you've seen a packet of tobacco products or cigarettes, they look quite differently to here. So there's nothing, sort of compared to plain packaging. You still have logos. Health warnings are actually not very large. And the reason is this case from 2012, where the FDA, so the Federal Drugs Food and Drug Administration in the US tried to impose combined health warnings, so both image and text, sort of enlarged also to cover 50% of the overall surface of the package. And here the court was very clear, this is compelled speech. So the government is trying to have these tobacco manufacturers, sort of speak things that they don't want to speak. And so in order to do that, the government needs to justify that, sort of needs to provide evidence, and it applied intermediate scrutiny, so, sort of quite high, needs to provide evidence that this will lead to a substantial reduction in smoking rates. And here you can see that the court says the government has not provided a shred of evidence, much less substantial evidence, showing that the graphic warnings will directly advance its interest in reducing the number of Americans. But if you look at the first paragraph, it says this case contains an element of compulsion, right? And forced subsidization of speech. And that's how speech was triggered in these cases. So here again, these are just examples. There's there's more examples in the article. The main thing that I'm trying to say is we should move away from just conceptualizing the interaction between trademarks and speech as what occurs in infringement litigation, where speech is limiting trademark rights. I believe we should look at it, sort of more holistically and understand that speech and trademarks interact in different instances, and that it operates as a two-way street where sometimes speech will validate trademark rights and sometimes it will limit trademark rights. What are the implications of the proposed approach? So why do I think it's worthwhile, sort of for us to spend time thinking about this? And I think there are a few advantages. The first advantage is I think it allows for better understanding of this interaction. If we have a better, sort of more refined understanding of the different interests that are at stake in different interaction cases, I could believe that it could result in better, balanced, fairer adjudication. Also, the second point, and hopefully from my examples, you can see how the analytical frameworks employed in the US and Europe bear similarity. That doesn't mean that the role that freedom of expression is doing in each jurisdiction is exactly the same, but the analytical frameworks are very, very similar. And so there is room for fruitful exchange of ideas and, sort of analytical frameworks, just to repeat myself, between both jurisdictions in this particular area of law. So one of the things that I noticed from the scholarship is there was a very clear divide between the US and Europe. This divide can mostly be explained because it's true that when I present this work, most people say, but the First Amendment is very particular to the US. And so, exporting the lessons from the US to Europe, how valuable is that? But hopefully I've given enough examples of the same analytical frameworks operating in Europe. So maybe there is something that can be learned, even if the scope of protection afforded under the First Amendment is not the same that what is afforded here under sort of the fundamental rights freedom of expression under Article 10 of the European Convention of Human Rights. I think sort of points 3 and 4 are probably the more sort of relevant ones. Point 3, so the idea that the sort of interpretive tools that we employ in one form of interaction can, and I believe should, inform the way that we interpret and understand other forms of interaction. What this means is that, and this is just an example, but I think it's the example that is easier to see. When you look in the context of infringement litigation, you have a lot of courts that are saying we need to insulate defendants' unauthorized use on the basis of speech, because this is it is deserving of a heightened degree of protection because it tends to be deemed artistic or political expression. When you then go to the registration context and also sort of challenges to the validity of measures that restrict trademark use, so again, sort of mostly for tobacco products, courts tend to say sort of here speech, because it's mostly of a commercial nature, is entitled to sort of a lesser degree of protection. My argument is, if we are saying in infringement litigation that it is, sort of defendants' use can be insulated as political or artistic speech, and so therefore gets sort of higher degree of protection, in the registration context, for instance, then it should also necessarily include artistic or political and not only commercial, because potentially a right holder could use this trademark for many purposes and to convey many messages, including messages of a political and an artistic nature. And so nowadays there is an inconsistency there between the two forms of interaction because we are not communicating between them, right? So we are looking at them in an isolated manner. And so I think there are lessons to be learned from what is going on in other instances, especially if we want to apply human rights law consistently across the different forms of interaction. So if in one form of interaction is political speech, well, then in another form of interaction where it could be any form of speech, then it should also include political speech, right? Again, that's just an example. There are more ramifications or examples where if we look at it holistically, things might have to change. And then the fourth point, which I think is I mean, is the point that probably carries more weight, or I think is the more relevant point to be made in this regard, because I think is what could really help us moving forward. It does open the door to reconceptualizing the interaction between trademarks and speech as conflicting forms of speech. And so therefore, for instance, in the infringement context, instead of looking at trademark rights as property rights, if we look at the expressive interest of the right holder in preventing the defendant from using, sort of making that unauthorized use of a modified version of the trademark for expressive purposes, then what we have is a balancing of fundamental rights between speech and speech. And so I think then it becomes more commensurate. And the kind of work that I'm trying to do now is to try to think, well, how does this then impact the way that we can conceptualize of that, sort of specific form of interaction as conflicting forms of speech? What does that look like in the context of infringement, in the context of registration, and in the context of sort of measures that limit or restrict use of trademarks? What does that actually mean? And that's the kind of work that I'm trying to do now. And that's why I said that this is very much, sort of a preliminary or first stage. But there is promise, I think, in trying to sort of look at it in terms of conflicting speech. And before people start asking, well, is that going to give too much power to, sort of right holders? Actually, I think that when we conceptualize this as freedom of expression, it will help us to understand that the expressive interest of the right holder usually will have to yield to the expressive interest of the defendant, again, on the basis that these are very well-known trademarks in most instances. And so proving that sort of the isolated use by that defendant will have an impact on the trademark owner's ability to express itself through its trademark is going to be very, very difficult, right? But again, I mean, I think that this is sort of what is probably sort of the core of the contribution at this stage, and it can actually sort of open the door to sort of reconceptualizing how we approach this interaction. That's all on my part. Hopefully that, I mean, I stuck to time. I didn't really know how much time I had, to be fair. But, hopefully that was sort of interesting enough. And yeah, I mean, I would like to open it for any questions or comments or contributions. Thank you.